and good morning, everyone. I'm Shivaji Shiva, partner in the charities team here at VWV, and this morning's session is intended to provide a practical introduction to charity disputes and some reflections on things you can do to avoid them. As you've heard just now, there's a Q&A function, so please feel free to use it as we go along to highlight issues that you'd like to know more about. Or to ask me to clarify if you feel an issue is not as clear as it might be. Can we have the next slide, please? Thank you. And the next slide. So you'll have seen, we call this a warning for charity leaders. That's really about saying it's not unusual for our clients and contacts to respond to our invitation to come along to a session on charity disputes by saying, why on earth would we do that? We aren't in a dispute at the moment. And at the same time, we see quite a number of complex governance disputes from organizations of all sorts in the charity sector. And so it's very clear, to us at least, that most of the organizations we deal with are perhaps one or two bad meetings, a slight relationship breakdown at board level, or some other small prompt away from having a difficult internal dispute to manage. So we're keen to see both trustees and members of the executive team at charities across the sector prepare their organizations for the possibility of a dispute. And begin to ensure that they are absolutely clear about the things that you might need to do if a dispute arises. So as you see there on the back, on the slide, what we're hoping to cover today, what I'm hoping to cover today, is a quick look at the charity sector context, a look at a key distinction that underlies the treatment of disputes here, and a look at some charity law issues before looking at perhaps some practical tips that might be of use. It's worth starting though by being clear about what we mean by disputes. And charities, as you'd imagine, encounter disputes many of the same ways as other organizations. Sometimes those disputes develop into legal proceedings, and they may even result in a full court hearing. In this talk, what we're focusing on is, in particular, two aspects of dispute resolution. This is not so much about the sorts of operational disputes that you get day to day, contractual claims, employment disputes, that sort of thing. It's much more about the sorts of internal disputes that arise where either charity trustees begin to differ and can't resolve that around the board table, so that a dispute arises about what the right way forward might be, or even about who is entitled to call themselves a charity trustee and to take an organization forward. Or situations where there is a complaint externally and perhaps there's regulatory action, and that can often prompt a very similar situation where trustees are seeking to establish that they are genuinely in control of the organization and they should be in that position. And as well as having a dispute involving trustees, it's not unusual for those charities that have a membership, whether a wide association membership like the National Trust or an organization of that sort, which perhaps elects members of the board, or a smaller membership that many organizations have that just involves a relatively small number of individuals beyond those on the board of trustees. In either case, it sometimes arises that the charity trustees and the members differ on an issue, and there's occasionally an internal dispute where, for example, a group of members are alleging that the charity trustees have not fulfilled their duties properly, have not run the organization properly, and perhaps are not are not properly appointed as charity trustees and should therefore step aside and allow someone else to run the organization. The session highlights in particular two key aspects of dispute resolution that are peculiar to charities. The first is the sometimes complex regulatory framework that charities operate within. Charity law imposes a range of obligations on trustees when a dispute arises, and it's important that people are aware of that. And then secondly, the particular issues that arise where a charity becomes involved in an internal dispute. Governance disputes involving trustees, members, or other supporters, as I say, can be especially damaging. If they aren't resolved decisively, they can stop the charity from functioning effectively, and they can severely damage a charity's reputation. In the worst cases, internal governance disputes can pose a greater threat to your organization than external threats. Sometimes you'll be faced with both types of dispute at the same time. To take an example, consider a group of individuals, some of them unidentified, gaining access to a community centre under a pretext, changing the locks, and then when the trustees take proceedings for possession, at the first hearing, the defendants claim that they became members of the charity at a recent annual general meeting, and they are entitled to control it. Now, that's an example that's drawn from and inspired by real life examples, and it obviously combines two issues: the proceedings for possession of a building, which any charity might find it's involved in if it owns a building, perhaps because trespassers get involved, or, and on the other hand, an internal dispute about about who's entitled to govern the charity. Now, the focus of this talk is to look at how we might spot potential disputes early, manage those disputes effectively, reduce the risk of disputes turning into full-blown litigation as far as you can, and maximize your chances of a quick and successful outcome, considering some practical tips. There are a whole host of simple things that can be done to help avoid having to speak to litigation lawyers. Much of that's common sense. But I suppose a key point when dealing with things going wrong is to take a deep breath and not allow other people's panic to sway your actions. So moving on to the next slide, please. Thank you. A kind of preliminary issue to consider is there a risk of personal liability? Could you be personally liable? And this is obviously a particular issue for the charity trustees. So focusing on them, whenever a charity is involved in a significant dispute, the trustees should be considering both the scale and nature of the potential liability to the charity, of a contractual claim, of the cost that might be associated with an internal rift and the resulting litigation, but also their personal position. And an important first step is to ensure that you understand the legal structure of the charity and the implications of that structure for the legal position. The obvious question is the charity incorporated? Has it been established as a company, a charitable incorporated organization, or in one of the other legal forms that mean that it's treated as having its own legal identity separate from that of the trustees, and the additional layer of protection provided by limited liability, so that unless charity trustees have failed to meet their duties, the liabilities involved will be those of the charity and not of the trustees. If the charity is unincorporated, on the other hand, the proceedings will usually be taken in the name of the trustees, and clearly having a letter from the courts or from the lawyers on the other side drop onto your doormat at home brings the risk very much to the fore. And if an unincorporated charity has insufficient funds to meet any claim, its trustees may be personally liable, irrespective of whether there's been any fault or breach of duty on their part. Some trustees of charities with substantial assets to draw on may be tempted to be complacent on this point, but would encourage you to consider the situations where even quite well-established organizations have gone astray. And the example of the Diana Fund is a reminder of why that sort of complacency simply isn't wise. Now, this is an example that was illustrated by Andrew Hind, who, as we know, is, among other things, a much respected former chief executive of the Charity Commission. He found himself in difficulties on just this score. in an article in Charity Finance, he was reported as saying that the stickiest situation he found himself in was as a trustee at the Diana, Princess of Wales Memorial Fund, after it decided to sue the Franklin Mint for breach of image rights. As some of you may remember the case, the decision to sue the Franklin Mint set off a catalogue of events that Hind described as a charity traffic accident of immense proportions. He'd joined the fund as a trustee in 1999. A year before that, the fund had started the lawsuit against Franklin Mint. The Mint had produced a Diana doll, which was not licensed by the fund. The fund believed it owned commercial rights over Diana's name and image, and Andrew Hind was one of a number of second wave trustees to join the board. After that, a 6-year legal battle ensued, and after the fund lost, the Franklin Mint countersued, claiming the fund had acted maliciously. The countersuit personally named all the trustees and was for a sum of well over $100 million, Hind told individuals in this article. That was greater than the reserves of the Diana Fund, and the killer blow, he said, was when we realized that the fund had not been set up as a limited company. It was merely a charitable trust. You can imagine that if someone with the deep knowledge of the sector and of charity law and governance that Andrew Hind has can find himself in that position, it's a position that almost any of us might find ourselves in, even at an organization like the fund, which was clearly very well established and resourced. Moving on to consider further the situation where the charity is incorporated. So it's set up as a company or charitable incorporated organization or another similar structure, and therefore has the advantage of limited liability. Even then, that if the charity trustees can't demonstrate they've fulfilled their legal duties, there will be a risk of personal liability. And the Commission's guidance on litigation generally, CC 38, reminds us about this, saying, trustees who act in breach of their legal duties can be held responsible for the consequences that flow from such a breach and for any loss the charity incurs as a result. When the Commission looks into cases of potential breach of trust or duty or other misconduct or mismanagement, it may take account of evidence that trustees have exposed the charity, its assets, or its beneficiaries to harm or undue risk by not following good practice. Excuse me just a moment. Just need to shut a window there. We've got a helicopter hovering overhead. I hope that hasn't caused too much noise for those of you listening. So, thinking about that issue of breach of duty, the good news is that the steps that are required to protect the charity are also key steps in guarding against personal liability. And these are largely the common sense steps you might expect to take. They'll include defining the problem, whether this involves analysing in an ordinary sort of dispute, an operational dispute, the contractual position on a dispute over payment with a commissioning body, or as in the context we're focusing on here, establishing who the parties are in an internal dispute and what it is exactly that they want. Then there's being clear about the issues from the charity's perspective. The core question here is this a dispute that it's in the interest of the charity to pursue? It's easy to allow personal considerations to cloud your judgment when faced with a potential dispute. And the sense of ownership that volunteer trustees can feel often exacerbates that. So a common and often tricky category of dispute relates to unwise statements by trustees at a board or member meeting. And it's worth saying in that context, we'd encourage you, not to make those statements in the first place. It's quite helpful once a dispute has arisen to plan meetings closely to avoid the temptation to ad lib in a way that may cause difficulties later, but also to resist the temptation to leap to legal action if someone else says something that is or may be defamatory. These are of course situations that require individual legal advice dependent on the facts in each case, but there is a regrettable tendency for organizations to find that they're spending a lot of time and effort on essentially unproductive litigation, where individuals allow themselves to be drawn into that sort of tit for tat situation of allegation and threatened legal action. Most of us who perhaps are used to seeing celebrities exchange arguments of this sort on social media have a good sense of the futility that often seems to underlie these exchanges. Now, as I say, that's not always going to be the case, but there's certainly a need for caution. There's also a need to ensure that the decision-making process is clearly recorded, and in particular, that decisions made by the board are properly minuted. It's not unusual to find that a board has got to grips with the problem well, thrown a lot of effort at reaching the right decision and carefully considered those decisions, but when asked by their lawyers to produce the minutes of the complex decision they've made, they can't locate those minutes because things were moving so fast that no one managed to record the precise nature of the decisions made. So it's really important that there's someone who takes the time to record the decision-making process well, and that may involve involving a third party, someone from outside the organisation, to support that. And of course, taking advice where appropriate, which is often, as you all know, a key line of protection to charity trustees against the allegation that they haven't fulfilled their duties. And then in terms of steps that we can take, and I wonder if we could have the next slide, please. Thank you. The next series of steps that will generally arise in this dispute that we might have, let's say a dispute between members of the board, looking at who should be in control of the organisation. In my current case, though, that's quite often a large membership charity, perhaps a faith organisation, where 2/3 of the board think the organisation should be controlled by them, and the other third think that actually there's a separate group should be in charge. So it's really important that you identify potential issues and protect the position of the charity at an early stage. Disputes rarely explode into life. There's generally a slow burn, especially where complex issues are involved. And if you can catch a dispute early, there's a greater chance of resolving it before views become entrenched, and the impact on each party becomes too great to resolve amicably. For instance, if you're dealing with a contract, so not an internal dispute for the moment, but a contract, the biggest warning sign is often when a party starts to deviate from its obligations, making changes without agreement or without following the correct process, or failing to meet deadlines and the required standards. In the case of an internal dispute, the equivalent warning signs would include trustees making decisions without holding properly convened meetings, and members seeking to influence decision-making without formal procedures. So perhaps seeking to make decisions in a corner of a meeting room rather than actually opening it up to the full membership. Don't ignore that sort of thing. If left unchecked, you can be storing problems for the future. Over time, these and similar issues can lead to one party arguing that, for example, critical governance changes have been validly made, while the other says those changes did not meet constitutional requirements and are invalid. And to underpin the work done to clarify the issues, it's important that there's clear communication resulting in a paper trail. It's extraordinarily common for a member of the team here, whether it's me or one of the other teams across our offices, to find that a trustee or a chief exec comes in and raises concerns about what has been a long-running dispute and starts to relay what is clearly a series of issues that have been going for months, if not years. But when asked to produce documentation, and in particular, a really clear statement of either side's position, there isn't anything there. There've been a series of tactical skirmishes, emails about particular meetings, accusations that people aren't properly appointed, concerns about the way that a particular election at an AGM was conducted, but no one has taken the time to slow down, step back, and set out carefully the position of their party, their group, or indeed the organisation as a whole. So if possible, what we want is to solve the issues, or to narrow the issues at least, by communicating with the other party, and to see that in writing, creating the paper trail we've just discussed, which can be produced if it results in a full-blown dispute down the line. And it sounds really obvious, but it's really helpful if at all stages it is clear from the correspondence that the Board of Trustees as a whole, if you're dealing with an external group, a group of members or similar, or the particular group that you're dealing with, has made clear that they're seeking to resolve matters and not making this an all or nothing situation. So it's really helpful if there is evidence of seeking to find a way of resolving the dispute informally, or to find a middle ground. So can we have the next slide, please? So the next step then is, you've got this dispute, you've started to work out what the issues are. Perhaps you've got to the stage where the first exchange of emails or the first short informal meeting has not resulted in a solution. It's not going to be easy to satisfy the aggrieved member that the election at the last AGM was properly carried out and is valid, and he or she is going to continue arguing that the board members appointed at that meeting are not properly appointed, for example. Whatever it may be, you know that we're getting into a more involved and difficult stage of the dispute. At this stage, the board is likely to be considering getting legal advice, and whether or not that's the case, a number of key questions arise. And from my perspective, they're as framed on that slide. So, whose dispute is this? Who exactly is the client? It's not unusual for a situation to arise where it's not entirely clear whether the dispute is between the charity as a whole, the board as a whole, and other individuals, or between two different factions, so that neither faction can truly be said to speak for the charity as a whole. It's also not unusual to find that there is a deep uncertainty about the true situation because of factual disputes about the background, whether that's the proper form of the constitution in a situation where, for example, the up-to-date constitution hasn't been filed with the Charity Commission, or as in a recent case we dealt with, that the 3 different constitutions are circulating in 2 different languages and with other key differences, and no one is quite sure which one was properly adopted. In addition to that sort of factual uncertainty, there'll often be quite a complex legal analysis to be needed to analyze the provisions of the constitution, the impact of different scenarios for each stage of what might be multiple constitutional meetings or other issues, and what that means. And until those things have been resolved, it may be the case that neither group can truly say we represent the charity. And so there is a really important question about whether they're entitled to spend the funds of the charity in seeking advice and taking other steps to resolve the dispute. So it becomes critically important that thought is given to whose dispute is this? Is this a trustee or group of trustees seeking to retain power and protect their own role as trustees? Or is it genuinely the organization, having decided through a properly convened board meeting, taking action to protect its own interests as an organization against what might be suggestions from others that the organization is satisfied are not valid? At the same point, as well as running through those issues and seeking advice, it's important to think about whether alternatives to legal action have been explored. And again, this is an area where it's really helpful to have a degree of independent advice to involve someone who's at arm's length. In some cases, it might be possible to involve one of the charity stakeholders, perhaps an elder in a faith community, or a funder, to help explore possibilities. But in many cases, that will fall back to professional advice. And issues to consider at this point will include the guidance that the Charity Commission provides, for trustees involved in disputes, and in particular, that trustees have a duty to protect or secure their charity's assets, and where necessary to recover assets belonging to the charity, and to take or defend legal action where it is necessary to fulfill that duty. A charity's funds must be spent on carrying out its aims, and the trustees have a duty to act in the best interest of their charity. So a decision to take or defend legal action must be made exclusively in the best interest of the charity, having considered whether or not another course of action is available. So again, that would throw into relief the question of whether or not this is really an issue for the whole charity, the board as a whole, or whether it's an issue for just one or two trustees seeking to protect their own individual interests. And in making their decision, the trustees will need to take and consider legal advice, consider and assess the economic prospects of success or failure and the impact on the charity, consider whether their intended actions are proportionate in the circumstances, decide whether it's necessary or appropriate to ask for the Charity Commission's consent or advice. And whatever the outcome, the downsides are typically the cost, time and money, in time and money of the process, and the reputational impact of any dispute. So unless time constraints for bringing or responding to legal action prevent it, the Charity Commission will usually expect trustees to explore, and if appropriate, rule out all other reasonable options open to them to resolve the issue, including alternative dispute resolution or seeking a legal compromise. Can I have the next slide, please? Now, assuming at this stage and having taken advice, there's a decision that pursuing the dispute is worthwhile, there is clearly a need to really understand what's at stake, considering the financial value, if there is a financial value, and the bigger picture issues. Are we talking about a situation where a failure to resolve a constitutional uncertainty might result in regulatory action by the Charity Commission? Are we talking about an issue which might give rise to reputational concerns? Because, for example, it's alleged that you haven't taken the steps you ought to have taken to control the buildings that the organization uses, or to manage the use of social media in an appropriate way. Are the costs proportionate? That's a fairly straightforward issue normally. And then formulating a strategy, really narrowing down the issues and making clear whether everyone is agreed on the outcome that you're aiming to achieve, the remedies available, how you're going to get there, and who you need in the room, who you need to involve in the way of professional advisors. It might be lawyers, perhaps accountants, often public relations professionals, communications professionals, in order to ensure that the process can be managed effectively. Have the next slide, please. And a key question at this stage is whether or not the dispute that's involved amounts to what are called charity proceedings. Now, charity proceedings are defined by section 115 of the Charities Act 2011, and they define a particular type of legal action, which relates to the internal administration or domestic affairs of a charity. So this might include many of the examples that we've touched on so far this morning, whether a charity's annual general meeting has been properly conducted, whether the trustees, who are in fact governing the organization, have been properly appointed and are properly entitled to take that role, an attempt to remove a trustee from office, an attempt to take action perhaps by a member for breach of the trustee's duties, otherwise challenging the trustee's decisions about the particular course of action that the charity is taking, or other disputes about control or misuse of a charity's property or resources. We're seeing and continue to see a large number of these disputes. We've seen a bit of an uptick in such disputes from the lockdown period, the COVID pandemic and lockdown onwards. It felt at the time as though that was being prompted in part by the real stress and challenge faced by boards having to make often critically important decisions that affected the future existence or not of their charities, with a very limited factual background available to them, and at rapid speed against the background of fast-moving regulation, which wasn't always well communicated. But I think the trend continues, at least in our experience. I don't have any research to base that assertion on. And certainly we're seeing quite a number of disputes within faith charities. And you can see the sorts of things that arise if you take a look at the Charity Commission's website and at the front page, where you'll see a range of organizations mentioned because the Charity Commission has appointed an interim manager to resolve what they see as long-term governance failings, or has become involved because there is an internal rift of some sort. And an example of that is actually the example that mentioned some of the publicity for this webinar, which is a decision of the Charity Commission in relation to one of its inquiries relating to the Ethiopian Orthodox Tewahdo Church, St. Mary Tsion. Now, this was a charity registered in the late 90s, governed by a trustee, and essentially the Commission became involved in large part because a religious schism had created two separate factions within the charity, and as a result, an entrenched and long-running dispute over who exactly was entitled to take on the role of trusteeship and manage the charity. As the Commission puts it, this was causing disruptions to the charity's religious services. In fact, it impacted on almost every aspect of the organization's activities. As a result, the Commission got involved and eventually transferred the assets of the charity to a charitable incorporated organization, and saw that as the future for the charity. This sort of followed a path that isn't unusual for disputes of this sort, in that there were High Court proceedings running in parallel. There were named interim trustees who were directed to take the steps required to establish the charity with an approved board. In this case, by registering a new charitable incorporated organization, and then working with the Commission to appoint trustees and transfer the assets of the charity to the new CIO. What's interesting in terms of the session here, and people seeking to understand some of the practical impacts of disputes internally, is that the Commission concluded that the dispute at the charity directly contributed to all of the issues the charity faced. Individuals on both sides of the dispute were unable to put their differences aside and cooperate for the benefit of the charity and its beneficiaries. So this deep division. The Commission couldn't justify seeking to determine exactly what had happened in that period, which will have no doubt left many of those involved dissatisfied, because there wasn't a clear finding as exactly what the history of the administration of the charity while the various charity proceedings were ongoing was, and that a significant amount of time and resources of the charity had been expended on trying to resolve the dispute and related litigation. So for many, that will have no doubt been a fairly unsatisfactory resolution. But the Commission identified, as it normally does in these cases, some issues for the wider sector, and said it expects trustees to consider legal action only after they've explored and, where appropriate, ruled out any other ways of resolving the issue in dispute, and highlighted that legal action can present the significant risks we've identified. In this particular case, the Commission actually authorised proceedings in the High Court to determine the identity of the trustees, validity of the charity's trust deed, and if valid, whether it and subsequent bylaws had been effectively adopted. So going back to the question of, are these charity proceedings? Key question in terms of why it matters. Why do we care? is that often, if you're not certain, confusion can arise between, as in the example earlier, apparently straightforward possession claim and charity proceedings. In that case, that possession claim turned into charity proceedings because of allegations made at the hearing that, in fact, the individuals who had sought possession of the community centre had become members of the charity, and indeed were entitled to act as charity trustees. In a similar case, or in a similar example, a dispute over the manner in which the staff of a care provider were structured has been deemed to be charity proceedings because the governing document of the charity included provisions as to the way in which the care would be delivered. And so it's important to understand all of this, because if consent is needed, and where you have charity proceedings, the consent of the Charity Commission is required before those proceedings are brought, or in the absence of the Charity Commission's consent, or if it says no, potentially the consent of the court. And if consent is needed and has not been obtained, the proceedings may need to be stayed. And it's not unusual for a court hearing to be stopped short because one or other party persuades the court that the dispute at issue amounts to charity proceedings and can't be pursued unless the consent of the Charity Commission or the court has been obtained. There are also circumstances where a claim can be made or at least started without commission consent because of the urgency involved. If you need consent, that can consume a lot of time because the commission's under-resourced and may take time to consider an application. A period of up to 10 weeks is standard, and it may well be considerably more. And in order to consider that application, the commission usually requires a lot of material, including evidence the mediation has been tried or is unlikely to succeed, so that you've got together to try and resolve the matter with the other parties. Particulars of claims are formally drawn up, details of the legal claim to be made, and evidence of advice having been sought on that claim and its prospects of success. Often you'd go to a specialist barrister at that point to get advice on the prospects of success, and often to help draft the particulars too. That advice is likely to cover a number of other factors that the commission will normally look for, including the cost estimate, the value of assets involved, up-to-date information about the charity's finances, a look at the benefits and risks which might flow from successful legal action, an assessment of the risks associated with going ahead more generally, including risks to the reputation of the charity, and the prospects of mediation or compromise. All of this needs to be set out in full, and if the commission decides it can't make an order, there may then have to be a further application to the court to see if the court will make an order. So you can imagine that process alone can involve significant legal cost, time, and energy. You might find that takes 3 or 4 months and involves tens of thousands of pounds worth of work. So, a key question: are there charity proceedings? Next slide, please. Another key question where the dispute arises is when and how to involve the Charity Commission. Actually, just before I go on to that, I see we've got a question in the chat, and it relates to the example of a charity becoming a CIO. The question is, does a charity becoming a CIO help to avoid disputes due to their more exacting procedures? The lawyerly answer is it depends, but to expand on that and try and be a bit more helpful, many of the disputes that I see arise in the context of charities that have governing documents that are less than helpful. So a typical example would be a community organization which essentially created its own governing document, perhaps using a Charity Commission model and then making culturally appropriate amendments to reflect the particular way that it operates, or in similar context, a sports organization choosing, because it's run entirely by volunteers, to create a wide range of officers of the association, and as a result, quite a large board. That can certainly make it harder to avoid disputes, and the sort of uncertainty about simple things like the process for conducting a general meeting often creates the space in which disputes can arise. A CIO or any charity with an up-to-date and well-structured governing document helps avoid that, because it becomes easier for everyone to agree what the right process is, and the governing document should be better drafted, and will be if one of the commission models has been used well. And as a result, I would say in that context, it does help to avoid disputes. But otherwise, the key change is not so much that it helps to avoid disputes, but that the CIO offers the trustees and members the benefits of limited liability. I hope that helps. So going back to involving the commission, we had an interesting comment on this recently, I think in April this year, from the chair of the commission at, so the chief executive of the commission at Trustee Exchange, where she made a speech requesting that the sector and charity trustees don't try to weaponize the commission as a tactic in a quarrel with fellow trustees. It was interesting in part because it sort of reflected, from the commission's perspective, a frustration that many trustees and charity staff feel, which is that actually they'll often feel that the commission is anything but weaponized, however long they ask, in that they can't get what they would see as a decisive and helpful response from the commission, because the commission has to try and approach these situations neutrally, and has some real limits on what it can do to help. So in thinking about that, we can go back to, when will the commission get involved? Well, often key prompts will include the likelihood of serious damage to the reputation of the charity or of the charity sector as a whole, the loss of charitable assets, or the likely loss of charitable assets, really clear mismanagement or misconduct, which is likely to result in further damage to the charity, its work, or to its reputation, and factors of that sort. It will also consider carefully whether it can get involved, in light of whether it thinks it can help resolve the situation, for example, by exercising a power under the Act, such as removal of a trustee, or by providing focused advice to help move things along. Or it needs to get involved because it's providing or considering providing consent to charity proceedings. It won't get involved, the commission will not get involved, where the issue is one for the trustees. So it's a resolution of a commercial employment dispute. It's not unusual for disgruntled individuals to complain to the commission in those circumstances. So quite often, if there's a dispute going on, the commission will get a barrage of emails from various interested individuals making a variety of complaints. And many of those it will have to politely deflect on the basis that they're issues for the trustees and not for the commission. It won't get involved where there's an internal dispute. It hasn't moved as far as charity proceedings, and the commission simply doesn't have the resources to determine the right way forward. We see this very, very often in the context of disputes, often within, volunteer reliant sports associations or faith charities, where a dispute arises. The parties both look to the charity commission to resolve it, but the commission just doesn't have the resources to get involved. And in most such cases, what's likely to happen is that the case officer sends a fairly standard letter recommending that those involved consider mediation and file the letter of complaint or maintain a watching brief. The commission also won't get involved where there is a factual dispute which only a court can determine. And often these situations where there's a dispute over whether a particular election was carried out correctly, or many of the other disputes that can arise where there's a long history of slightly loose governance, will result in a situation where the commission doesn't feel able to get involved because it can't readily get to the bottom of what's actually happened, because it doesn't have the power to make those factual determinations. And so it would expect, and often will write to the parties to tell them that if they really want to take things forward, they may have to go to the courts, and to do that, they're going to have to go through the process of getting consent, and therefore, before that, go through the process of seeking mediation and taking the other steps that we've discussed. Sort of help that the commission might be able to provide include practical intervention, for example, removal of a trustee, where there's focused need and a good case can be made. Providing formal advice under Section 110 of the Charities Act to provide trustees with reassurance that what they propose is consistent with their duties. So that a charity trustee who acts in accordance with the Commission's advice is to be treated as acting in accordance with her trust, i.e. they get some protection from legal action. In practice, the Commission is not eager to provide that sort of advice and will generally seek evidence that legal advice has first been sought on the particular issue. And the resulting advice is also often equivocal. In some circumstances, however, seeking advice can be helpful, and if an organized application is made, can get a very useful result. Next slide, please. So the next point is really quite a practical and probably self-evident one, which is that you need to notify your insurers and the regulators where disputes arise. You'll need to consider, in particular, whether you need to make a serious incident report. That might be to the Charity Commission or to other regulators. For example, higher education charities will also be regulated by the Office of Students. And there may be a need for serious incident reports. There may be a need for a report of a data breach to the Information Commissioner's Office. Generally, regulators will want to be notified at an early stage, even if it's just on an interim basis at the outset, and won't be impressed if they find out what's going on from elsewhere. A while back, a few years ago, we had an incident where the Charity Commission contacted a client to ask why it's not been notified of an urgent matter that had hit the press earlier that day. Fortunately, in that case, the client was able to show that it had in fact filed a serious incident report with the Commission the day before. But this does show how switched on the Commission can be to those sorts of issues. So you need to think about regulators. You also need to think about insurers. If you think a dispute is likely to arise, you need to check the terms of insurance, and you may have cover. You may have cover for the issue itself. You may have cover for the legal expenses that you incur. And you may even have public relations cover. It's also important that you notify insurers of disputes promptly. Most policies will require that you notify insurers of any circumstances which could reasonably give rise to a claim. And insurers may take quite a while to confirm the coverage position, and they may need to be pressed to confirm that they're going to meet the claim where things are urgent. And unless until coverage is confirmed, you're going to have to act as though A, it might not be confirmed, and B, you have to, if you're hoping that your costs are going to be met, you'll need to continue acting as a reasonably prudent uninsured person, which basically means that you shouldn't do anything which could prejudice the position of the insurers. So, for example, making an admission or offer without their prior approval. It may also be the case that any cost that you incur before the insurer gives the go-ahead may not be covered. Next slide, please. So a key component of managing any dispute, and as we've already touched on, it's a key issue in almost every internal dispute, is managing the legal costs incurred and ensuring it's clear who is entitled to use, whether the parties involved are entitled to use the charity's funds, and if so, which parties are entitled to do so. There's a significant risk of personal liability to trustees where a dispute arises, and a key component of that is the risk that excessive legal costs will have been incurred and they're unable to seek reimbursement from the charity. So a first line of defense against those difficulties is to get legal advice and support in managing the dispute. As well as that, it's important to remember the reputational risks where apparently disproportionate costs are incurred. The British Diabetic Association case is a good example of that. The context of that, as some of you may know, was a falling out between a charity and a former active volunteer and fundraiser. There was an allegation that the name of the new charity was misused, and because no trademark has been registered, the case was brought in what's called passing off, and enforcing an unregistered right. The case established that a claim of passing off could be brought in relation to the name of a not-for-profit entity, as well as commercial organisations. However, the resulting costs were very significant, and the judgment included a description of the cost incurred as a deplorable, even scandalous thing, a deplorable, even scandalous thing. So similar kind of reputational impacts can happen in any case. You'll want to be watching for that possibility. You'll also be, or trustees will want to ensure that they're not likely to be personally liable, having exceeded their authority in incurring costs. And a bedo order is a formal order authorizing the trustees involved to incur costs. That form of approach is less commonly used these days, with the Commission preferring to provide Section 110 advice, so to formally give advice that it's okay to incur the cost. If a bedo order is sought, it's important to remember that an application is itself charity proceedings. So applying for an order authorizing the cost is itself charity proceedings. So you need the consent of the Commission to seek a court order protecting you in relation to costs arising from starting the further claim. There's also a useful provision in the Charities Act 2022, which has just come through, which came into effect in October last year and provides for authorized cost orders. So if what's happened in the context of charity tribunal applications, so if a decision is being challenged by way of an appeal to the charity tribunal, instead of following those other approaches, it's possible to approach the tribunal directly and get an authorized costs order. Can I have the next slide, please? So that's been a bit of a kind of canter through some examples of charity disputes, how they might arise, and some of the things that you need to bear in mind where they do arise. And we've got about 7 or 8 minutes to go. For the last section, I suppose, of this talk, which gives you a message that will not be a surprise and is well signaled by the cliches on this slide. And that is that probably the most effective way of avoiding disputes relating to the internal governance of the charity is to ensure that you've got good standards of governance as soon as possible. These are all cliches for a reason, and it's surprising how often our clients find themselves able to systematically review and improve governance procedures after a dispute has arisen, when the situation just appeared absolutely intractable before the dispute. So, you know, let's review governing documents if they haven't been reviewed for 3 or 4 years. Let's have a look at, in a systematic way, at all the other governance procedures. There are models like the Compass CAS model. There are routine approaches like using the governance code as a starting point and perhaps challenging the governance code a bit. Then don't waste a good crisis. If a dispute has begun to arise, think of that as a way of saying, well, we clearly need to get that governance review done. And if people have been resisting the prospect of change, constitutional change, and any change is often resisted, well, let's take the opportunity to make sure it happens. And consider the nature and extent of the changes that are required. You know, that varies from an informal review by the charity trustees themselves to a comprehensive formal review conducted by external professionals, and perhaps more than one sort of external professionals. It's not unusual, particularly for larger or more complex organizations, to have you know, up to 3 layers: an internal staff team looking at the issue, a consultant providing sort of active support and convening meetings and that sort of thing, and some external expert advice from a legal perspective to ensure that the resulting changes hang together appropriately and are legally effective. We've found in a number of recent cases that that those formal reviews help identify a wide range of issues. And I suppose I'd say in closing, really, that as well as providing a prompt for considering those reviews, one of the things that the very frequently arising internal disputes demonstrate is that there's unlikely to be a quick fix to delivering good governance. That, as to return to Andrew Hind and quote him, I think from his book, The Governance and Management of Charities, governance is a subtle, multifaceted subject. And so it may well be that if the aim is to avoid a dispute arising, and put the organization in a place where the likelihood of a dispute is much lower, but also that you've got clear procedures for dealing with disputes, for removing trustees who get into difficulties, for taking contentious issues back to the membership, for ensuring that the people who are being proposed to join the board are properly qualified, have the necessary skills, knowledge and experience, as well as the time available to do the job well, by perhaps putting into place a nominations committee or similar. So those things may need to be done repeatedly. It needs to be a sort of continual improvement that's envisaged by the governance code.